accused from a considerable distance, especially when it was dark at the PO, is itself suspect. Stop. Prosecution unable to convincingly connect the jeep of the accused with the incident beyond reasonable doubt. Stop. Lapses in investigation, prosecution failed to prove its case beyond all reasonable doubt, judgment of High Court upheld. Stop. Section 302, evidence of PWs and informant contradictory to each other and evidence of each of them belies the evidence of the other, therefore, cannot be relied upon. Stop. Accused alleged to have stayed with the deceased, however, no consistent evidence which proved the same, and it cannot be confidently held that accused killed the deceased, further, abscondence of accused only aroused suspicion against him, however, mere suspicion cannot be made basis of conviction, conviction and sentence set aside giving benefit of doubt. Stop. Initial information given to police regarding occurrence was suppressed. Stop. FIR sent to magistrate after 3 days of occurrence, though distance between the court and police station is 12 kilometers. Stop. Appellants named belatedly after due deliberation, police officer who recorded further bayan was not examined. Stop. Postmortem report not bearing the case, no, it can be held that FIR was antedated, occurrence took place in the field irrigated just before occurrence, but there was no sign of trampling. Stop. Evidence of PW that hands and feet of deceased were smeared with mud as deceased was irrigating field, but no mud found on the body of deceased. Stop. Motive assigned for occurrence 2. Weak and still discrepancy in the evidence of eyewitnesses. Co-villagers who came to the PO after occurrence did not see the appellants at the PO or in the vicinity, though eyewitnesses stated that on seeing co-villagers, accused fled away. Relationship between the parties was not cordial, thus, there was possibility that appellants implicated out of animosity or suspicion, conviction and sentence set aside. Stop. Section 302/34 conviction plea that there is no circumstance to infer common intention, and as there was no meeting of minds, the conviction cannot be supported in aid of section 34, and that conviction of appellant number 2 is not sustainable since none of the injuries on the person of the deceased is attributable to lathi, which was supposedly in his hand, and prosecution case rests on the gun shot injury, appellants were convicted with the aid of section 30 of 4, accused persons were present at the PO, they were seen going away, and deceased was found lying in a pool of blood. Stop. PWs specifically are stated about the weapons being carried by the accused persons, absence of any injury caused by a lathi cannot be the governing factor to rule out section 34. Stop. Appellants accompanied the other accused persons who were armed with gun, and they themselves carried lathi and ballam respectively, and he himself was carrying a lathi. Stop. If the common man intention is established, an accused can be convicted. Stop. Their intention was to go to the shed where deceased was studying because of availability of the electric light established, common intention can be gathered from the facts and circumstances, and in the intent case, the same is clearly discernible, carrying of weapons, arrival at a particular place, and at the same time, entering into the said and murder of the deceased definitely attract the constructive liability as engrafted under section 34. Stop. Conviction, plea that as per deposition of doctor who conducted postmortem of deceased body, there was no blackening, no scorching present at the gunshot wound, the genesis of the entire prosecution case, that is the gun was shot from close range, can be discarded, that will not belie that injury was not inflicted by the firing from the gun, as you opined that death of deceased was caused by gunshot injury. Stop. Conviction, plea that testimony of all the principal PWs are not worthy of credence and that they are all related to each other, PWs deposed about the previous enmity between the parties, their presence at the spot, weapons they carried, their proximity to the said, and establishment of identity of all the accused, they also testified as regards the deceased lying in a pool of blood. Stop. No reason why they would implicate appellants for murder of their relation, leaving behind the real culprit, that apart, nothing elicited in cross-examination for which their testimony can be discredited. Stop. Section 302, Sections 7-A and 20 of Juvenile Justice Current Protection of Children Act, 2000, conviction appellant number 1 found are to be a juvenile being 16 years 3 months 10 days old on the date of offence and remained in custody for more than the maximum period for which he could be confined to a special home, while sustaining the conviction, direction to release him. Stop. Section 118 of Evidence Act, 1872, contradiction and some sort of development in evidence of the witnesses found, but the presence of informant found are properly stocked and heaving the injured witness, became stumped witness and on account thereof, his status became a upper ladder in terms of section 118 of the Evidence Act, the contradiction and variation in testimony of the witness do not go to the root of the case and the substratum of the prosecution. Person remains undisturbed. Conviction and sentence upheld. Stop. Section 304-B, dowry death. No credible evidence on record of deceased having been subjected to cruelty because of failure of her family to fulfill any demand of dowry raised by her husband or his family members, trial court rightly acquitted appellant under section 304-B. Stop. Sections 304-B/34, 302/34 and 201/34, dowry death, allegation of dowry demand, appeal against acquittal, clause relatives of the deceased denied any dowry demand, and that the deceased died accidentally, evidence on record showing clause relative of the deceased present at the time of her cremation, joint application signed by both the parties submitted before the police stating the death to be accidental, trial court rightly acquitted the accused of persons. Stop. Para.